Thanks. Good to be with you. So, why do you need insurance at all? Because you wouldn't need insurance if you weren't responsible for something. So, my first part of our webinar is just to put some foundations down of what trustees might be liable for. So, I'm going to start with the duties and responsibilities because if trustees didn't have any, then they wouldn't have any liability. So, I'm just going to explain those briefly. So, your key duties as charity trustees are what is known as fiduciary duties, which is really just a fancy term for saying that you owe, you're entrusted with some responsibility for the benefit of somebody else. So, the fiduciary duties, you owe them to the charity. So, charity trustees owe these duties to the charity and to its beneficiaries. There is no comprehensive list. I can't point you to the Charities Act and say go to section whatever and have a look. They've actually come from trust law over hundreds of years in cases. So I will touch briefly on them. But just to say that if you are a charitable company, then, in addition to these fiduciary duties of your trustees, who are your directors, will also have the directors' duties under the Companies Act. And surprise, surprise, they grew out of these fiduciary duties. So they're very similar, but just to flag that, if you're a charitable company, you're going to have similar duties that, in addition to these in the Companies Act. So, next slide, please. So I've listed there what the fiduciary duties are. So let's just touch on them briefly. So first, it is to promote your charitable purposes. So that means that you can only use the assets of your charity to fulfill your charity's objects. So, silly example, your charity is set up to look after cats. You can't spend your charity's money looking after dogs. That would be a breach of a fiduciary duty because you're spending money. Yes, it's for a charitable purpose. If you like dogs, that it's charitable to look after them, but actually it's outside your own charitable purposes. So that would be a breach of that duty. You've got to act within your powers. That means what does your governing document say? Sadly, Catherine and I get lots of instructions where there's been charities acting outside their powers. So, for example, paying trustees when they haven't got a power to pay them. You've got to act in your charity's best interests. And that rolls into the next one about managing conflicts of interest and loyalty. So you've got to act in your charity's best interest. That means not in your best interests. You have to act in the best interest of what is most beneficial to your charity. So, if there's a conflict with what's beneficial to you, I'd like to pay myself, then you've got to manage that conflict and make sure you don't take part in any decision making. Otherwise, you can be in breach of your duties. Got to manage your resources responsibly. If you're going to invest some money, you've got to invest it responsibly, not just with your mate who tells you he's got a good deal and can get you a good return. Any FDs on the call will understand that. You've got to act with reasonable care and skill. That's such a glorious legal term, isn't it? What does it mean? Well, it's been taken to mean that the reasonable care is what a reasonable business person would bring to the decision making, and the skill is your skill as a trustee. So if you're making decisions as a trustee, you've got to be reasonable, like this mythical reasonable business person, but you've also got to bring your own skills to it. So for example, if you're an accountant and you're a trustee, you can't leave at the door of the trustees meeting all your accountancy skills. You've got to come and bring those to the decision, and you'll be judged according to that. So I was once involved many years ago where an accountant, where a charity was being investigated by the commission, and it was a financial matter. And one of the trustees was an accountant, and he came under a lot more criticism than the other trustees because of his financial knowledge, which the commission had said he should have used. So that was interesting. You've got to act independently. That means trustees cannot be controlled by any third parties. They've got to act independently in the best interest of their charity, and the charity itself can't be controlled by another entity. And then, oh, the joy, you've got to make sure that your charity is always accountable to its regulators. So we all know about the Charity Commission, and they're a real regulator with real teeth. Also, you might have other regulators, for example, CQC if you're in health and social care, or the fundraising regulator if you're in education, Ofsted. So those are your fiduciary duties. Next slide, please. Next slide. Oh, one before that. I think we've jumped. There we go. So we've got, oh, yeah, that's it. That's the one. Brilliant. So I've listed, there are other duties and responsibilities away from fiduciary duties, and how these will apply, which I'm about to touch on very briefly in a minute, will depend on the legal structure of your charity. But I've listed there that trustees and charities can have contractual duties where they enter into contracts with third parties. They might be liable for negligence. If you've got employees, we all love data protection, don't we? Breach of data protection. Oh dear. Health and safety, and then you've got HMRC after you, maybe equality legislation, and absolutely key there, safeguarding whoever we're working with. So all of those are also come under your responsibility as trustees and can lead to liability. Next slide, please. So for my final slide, before I pass to Catherine, I'm just going to touch on then what is the potential liability for trustees. And I've headed it up. You can see there the incorporated charity myth. Lots of people in the charity world think that if their charity is corporate, then the trustees have no liability. And that is not correct. So what do I mean by corporate? So some of you charities come in all different legal formats. So you might be an unincorporated charity. For example, you might be a trust, or you might be an unincorporated charity with some rules. So that has no corporate structure, which means the law sees only the trustees, and it's the trustees that do everything on behalf of the charity. Contrast that with a corporate charity, for example, a charitable company or a charitable incorporated organization referred to as CIO. Then they have a legal identity, which means that the charity can enter into um, contracts, purchase property, and therefore it does give some protection. But where it doesn't give protection is, guess what? Breach of fiduciary duties. Because who do trustees owe them to? They owe them to the charity and its beneficiaries. So therefore, all trustees of all charities can be personally liable for breaching their fiduciary duties. How does that arise? Well, sometimes breach of fiduciary duties means a transaction can be set aside, which has a financial consequence for a charity, which a trustee can be personally liable for. If a trustee receives a benefit they shouldn't have received from the charity, they can be liable to repay it. An example there is if they're employed by the charity and there's no power to employ them, they can be asked to repay their salary. And a trustee can be liable to the charity for any loss it suffers um, because of their breach of duty. Go back to my silly example. The trustees in a cat's charity decide to spend money on dogs. Therefore, they've misspent the money, and therefore they can be liable, personally liable, to repay that money to the charity if they can't recover it. There's some other liability that applies to all trustees, regardless of the structure of the charity. That's criminal liability. I am pleased to say this is very rare. I'm sure now someone's going to type in there that they've come across it once, but it is very rare. But and obvious examples there are acting whilst disqualified. You're a trustee, you're disqualified from being a charity trustee, for example, because you're bankrupt. There's some criminal liability. And also there are certain situations when you're interacting with the Charity Commission where there is potential criminal liability if you don't comply with what you're being requested to do. But I am pleased to say they are very rare. And then finally, just to finish as I hand over to Catherine, liability to third parties. And this is where the difference often comes, whether your charity is incorporated, a company, a CIO, or unincorporated like a trust. Generally, and there are so many exceptions, but generally speaking, the liability to third parties, for example, under a contract in tort, if an employee sues you, sits with the charity and not with the trustees if the charity is corporate. On that exciting point, I will pass over to Catherine.
Thank you very much, Edwina, and hello everybody. Rob, if we could have the next slide, please, that'd be great. Thank you. Okay, so as Edwina has touched on, as charity trustees, you need to act within your powers and you need to manage any conflicts of interest. And the general rule that flows from these duties is that a charity trustee or anyone connected with them, they must not receive any payment or other material benefit from the charity that they manage and administer. That is, unless they're authorised to do so by, first of all, it could be the charity's governing document, it could be a statutory provision, so a law, it could be by particular order of the Charity Commission or of the court. And a benefit is really quite widely interpreted to mean any direct or indirect financial or other sort of measurable benefit of any nature, including benefits in kind, such as free use of a charity's equipment or property or services that users or beneficiaries would normally pay for. And it's standard practice for a charity's governing document to authorise a charity trustee and any person connected to them to receive a limited range of payments or benefits from a charity, as exceptions to that general prohibition that I mentioned. Now, typically, these will authorise all charity trustees to do two things. The first of these is that they can be indemnified against personal liabilities incurred in the proper performance of their duties. So if a trustee incurs a financial liability on behalf of their charity whilst acting as a trustee, they can be reimbursed by the charity from its own funds. So the relevant clause will usually contain restrictions. For example, it will not include any indemnity against liability to the charity itself for the reasons that Edwina mentioned before, for particular fines or penalties, or any liability incurred as a result of an unsuccessful defence of criminal or civil proceedings. Next slide, please, Rob. So the second thing that a charity's governing document will typically authorise is the purchase of a trustee indemnity insurance policy, and it will also authorise the payment of the premium from the funds of the charity. So the detail about what an indemnity insurance policy is and what it does, that will be covered a little bit later in the session by Alex and Ravi. But very, very briefly, a trustee indemnity insurance policy provides cover to a charity trustee or charity trustees against having to personally meet the cost of claims, including the cost of defending those claims that are made against them for various reasons, including a breach of trust, breach of duty, or negligence committed by them in their capacity as a charity trustee. Now, the insurance policy will only cover charity trustees against claims that arise because of their legitimate actions as charity trustees. It can't cover claims arising from willful or reckless breach of trust. The main difference between trustee indemnity insurance and other types of insurance that's taken out for the benefit of the charity is that this insurance policy provides direct protection to individual charity trustees rather than the charity itself. So this is why it's often helpful in successfully recruiting people to be trustees if you have that in place. Next slide, please, Rob. So if your charity's governing document doesn't contain those authorisations of trustee benefits and it doesn't allow you to purchase indemnity insurance policy, then it's likely that you as trustees will be able to rely on the statutory power to take out trustee indemnity insurance that's contained in section 189 of the Charities Act. So this statutory power overrides any general prohibition in your charity's governing document against you as charity trustees receiving benefits. The one sort of exception to that is that if the power isn't available, if your charity's governing document specifically prohibits the purchase of trustee indemnity insurance. That's very, very unusual to see that, very unusual to see it in practice. The one exception to that might be if you have a local authority that's appointed as the charity trustee of a charity, in which case, because it's a public body with the capacity to act as a charity trustee, that they should be prepared to accept the ordinary measure of legal responsibility for its actions without seeking insurance and an indemnity. So that statutory power that I mentioned in section 189, it has conditions. The first is that the charity trustees must be satisfied that it's in the best interests of the charity to take out and pay for the insurance policy. Secondly, the Commission expects charity trustees to be satisfied, having taken professional advice on the terms of the policy if necessary, that there is a genuine need to purchase the policy, that they've identified risks and potential liabilities that justify spending the charity's funds on the policy premium, that the cost of the cover is reasonable, not excessive, and that the policy proposed is suitable for the charity overall. Now, as I mentioned before, very briefly, the insurance policy mustn't indemnify a charity trustee against certain things. So it can't indemnify against fines imposed in criminal proceedings. It can't cover any liability incurred by a charity trustee in defending criminal proceedings in which they're convicted of an offence involving fraud, dishonesty, or, as I said before, willful or reckless misconduct, or any liability incurred by a charity trustee to the charity itself as a result of conduct that they reasonably knew was not in the best interests of the charity. So that's the end of my section. I'm now going to hand over to Ravi and Alex for the second part of our presentation. Thanks both.
Thank you very much. I think the biggest thing that stood out for me specifically was the incorporated charity myth. I think we often see that when we're giving advice to charities, and often we are asked the question, do I still need the cover? So that was a very interesting point. The next few slides we're going to talk about trustees indemnity insurance, very specific to the insurance aspect. I'll just go through some of the key topics on the next slide, Rob. And so Alex is going to be covering most of these slides, and what I just want to be very clear about is from the presentation, we're going to talk more about the exposure that trustees face, and actually the very specific challenges that charities and the third sector organisations may have to consider. Also, what scenarios could trigger claims, and if you were to purchase a trustee's indemnity policy, or if you have one already, how does it actually respond in a real world situation? And also, whilst the cover's very broad, what are the common exclusions? What's not covered? And also misconceptions and misunderstandings of the policy. Alex will also talk about some very specific claims examples, which are quite broad but would be relevant to charities of all different shapes and sizes. And we'll talk about the future landscape for trustees and governance. At the end, we'll go through some practical tips for you as well, so you can leave the presentation knowing there is things that you can do and there are options available based on what you might be looking for. I'm going to pass it over to Alex.
Thank you. Yeah, hello. Next slide, please, and we'll start. Lovely job. So what you've heard is in relation to trustees and what they're required to do and how the duties are defined in law. This slide talks about how what happens when those duties are questioned, not whether a trustee has actually done anything wrong. Trustees can be personally exposed to regulatory inquiries, investigations, or allegations simply because of the position that they hold. At that point, defence costs arise quickly, often before any conclusion is reached. While many charity documents allow indemnification, that protection depends on legality, wording, and whether funds are actually available at the time. Trustee indemnity insurance exists to make sure that the protection works in practice, not just on paper. Next slide for me. Even where trustees are legally entitled to indemnification, there are practical barriers that often prevent it from working when it's needed. Many charities hold restricted or designated funds that simply can't be used to pay trustee legal costs, even temporarily. Trustees may also assume that support of goodwill or future fundraising will help, but legal advisors need paying immediately, present company, not later. And at the same time, regulatory scrutiny has increased, so inquiries and investigations are happening more frequently. If a charity is under financial pressure or approaching insolvency, indemnity can fall away altogether, just as trustees are at their most exposed. I've laid out a few different challenges for you just to have a look at there. Next slide for me. So when we talk about trustee claims, it's important to be clear about how they actually start. In practice, they rarely begin with a finding of wrongdoing or a demand for compensation. They usually begin with a question or an inquiry or a complaint or a review of a past decision. That might be a charity commission inquiry that escalates an allegation that trustees failed to act, questions over how restricted funds were used, or a review triggered by financial difficulty. In all of these situations, the first thing that happens is that trustees need advice. So solicitors and specialists are instructed early, often before anyone knows whether there's a problem at all. That's why trustee claims are really about process before outcome, and why the cost issue arises long before responsibility is ever established. So I've got a few things here that are written up. So regulatory and statutory investigations, an example would be a routine charity commission inquiry escalates after a complaint, and trustees need legal advice before conclusions are reached. We've got allegations of a breach of duty. So a former employee of the charity or organisation claims trustees failed to act on governance concerns, even though no wrongdoing had been established. Misuse of or misapplication of restricted funds. Funds used for short-term cash flow pressure are later questioned as being outside their original charity purpose, which I think we touched on earlier. Charity insolvency events, when a charity enters financial difficulties, trustees' past decisions are reviewed as part of the insolvency process. And then legal defence costs normally arise first. So solicitors and advisors are instructed immediately, long before the findings or settlements ever discussed. Next slide for me. So everything that you've heard so far assumes that indemnity works smoothly and that funds are available. In practice, as we mentioned, that's not always the case, and this is where insurance steps in. When a claim or investigation arises, there are three common scenarios. First, if the charity is able to indemnify trustees, the insurer reimburses the charity for defence costs and settlements. That's the straightforward situation. Secondly, if the charity can't indemnify because funds are restricted, unavailable, or the charity is under financial pressure, the insurer can pay the defence costs directly to trustees. And then thirdly, where indemnity exists but is delayed or is uncertain, insurers can advance defence costs while those issues are resolved. So in simple terms, trustee indemnity insurance turns a legal right into immediate practical protection at the point that the trustees actually need the help. Next slide for me. Up to now, we've also focused on where trustee indemnity insurance helps, but it's important to understand where it doesn't respond. Again, we've touched on this earlier on, but there are some consistent exclusions across most policies. For example, claims linked to insolvency that are typically excluded, particularly where trustees are alleged to have failed to act in the right time as difficulties emerged. Similarly, pollution and contamination risks, things like asbestos-related issues, sometimes outside of the scope of cover. Another key areas where claims are brought internally, so by the charity itself or fellow trustees. These are generally excluded, although there are some limited carve-outs for cover, such as insolvency-related actions where defence costs may be supported. Definitely have a conversation with whoever you're insured with around that side of things. If it's also worth being clear, that again, we did mention earlier, Anthony Collins mentioned earlier, that there's no cover for deliberate wrongdoing or personal gain. But importantly, one individual's conduct doesn't automatically remove protection for the rest of the trustee board. So that's clear to be clear on as well. And then finally, claims involving bodily injury or property damage aren't covered under this type of policy, as you might expect, although associated investigation and defence costs can sometimes be picked up. The key takeaway is that trustee indemnity is designed to support governance and decision-making risks, but it's not a catch-all. Understanding these boundaries is just as important as understanding the protection itself. Next slide for me. Then some common misconceptions. This is some of the stuff that we hear from trustees and those that running third sector organisations tell us that they rely on, and it's often where reality is often more complicated. Many trustees or those running the organisations assume that the organisation will simply cover them if an issue arises, but in practice, again, as we mentioned, it only works if funds are available and usable at the time the costs are incurred. Others take comfort from the Articles of Association or governing documents that they have. Those can help, but only where indemnity is legally permitted and financially workable in the moment. Incorporation, bigger piece before, can also give a sense of protection, but it does not remove personal responsibilities or the possibility of investigations into trustee decisions. This grid gives an understanding of where assumptions don't always align with how the real world might work in practice. Next slide for me. And then I've managed to put together some claims examples. I hope it's big enough to read. These are anonymized claim examples, and they matter because they show how quickly everyday governance and decision-making issues can escalate into formal allegations and costly disputes. What I have put on there is in relation to the claims examples, it talks about who the claims are against, whether it's the organisation or the trustees, and you'll see a lot of it being both. So it's important just to have that distinction as well when claims do arise, that it could be both the organisation and you as individuals. The range as well as deliberate from alleged unlawful, not yet, alleged unlawful eviction at a retreat centre to a formal trustee challenging removal and exclusion from meetings, to a refusal of membership tied to alleged defamation, claims against trustees and the entity through alleged breach of statutory duty under the Wildlife and Countryside Act, and defamation linked into local media comments. These are illustrative figures that highlight a key point. Exposure is not just damages sought. There are often in these examples between 40,000 and 120,000, but the defence costs can also accumulate and ranges here from 8 to 110,000. So many matters run on for extended periods with outcomes not agreed for some time. The practical takeaway is to strengthen process and records, follow clear guidance procedures, document decisions and communications, and seek early advice and notify insurers promptly when a complaint or an incident starts to crystallise. Next slide for me, please. Thank you. And then before we move on to practical actions, while I pass you back to Ravi, it's useful to step back and look at what we're actually seeing across the sector from our point of view. First, there is clearly increased regulatory scrutiny. This doesn't just mean enforcement, it means more attention on governance, decision-making, and how trustees discharge their responsibilities. Alongside that, we're seeing much earlier regulatory intervention. Inquiries and reviews are happening sooner and more routinely, often without suggestion of wrongdoing, but they still require trustees to engage professionally from the outset. At the same time, there's greater personal accountability for trustees, expectations around oversight and challenge are higher, and trustees are more likely to be personally named in inquiries simply because of their role. All of this feeds into legal and defence costs and them rising. Advice is needed earlier, specialists are brought in sooner, and costs are incurred well before the outcome is known. So the result is that trustee indemnity insurance is increasingly seen as part of good governance. Not as a response to wrongdoing, but a way of ensuring trustees can engage properly and confidently when issues arise. Next slide for me, and then I'll pass you over to Ravi.
Great. So just to cover some practical tips that you can implement in your own organisation. So one of the most important things that you could do is review your current cover and review the governance that you have in the organisation. Does it have certain permissions? Does it authorise you to do certain things and make decisions in the charity? But the key thing is to remember that not all trustee indemnity policies are built the same. Some have far more exclusions than others. Some are very broad, and the way their policies respond differ. So it's very healthy in the organisation to make sure that policy is being reviewed, including including the indemnity limits, including the claims reporting requirements as well, and how the policy would work as well, on a long-term basis as well. So the other thing is actually ask, check what the scenarios are with claims. What policies and procedures are required in the organisation for you to have in place. Trustees indemnity is a board level. Any risk that trustees face is a board level risk. So the conversation of insurance and indemnity should be the same. So when you're reviewing your trustees indemnity, it should be alongside the entire program, because if you have claims under certain sections of your policy, some of them are required to be notified to the trustees indemnity insurer as well, and those things can be missed. While it might not be an injury, there could be a financial loss to the charity that's occurred due to a failure of doing certain things. Therefore, it's better to always speak to a specialist broker, get specialist advice, and keep the cover completely under review. At least, some organisations do it annually. We say periodically, maybe once every 3 years, but it's healthy to see what's going on in the market. The trustees indemnity market, which is also called the directors and officers market, is changing. Some insurers are very interested in writing more business. Some insurers are being more restrictive. Because the options in the markets change, and because it does move quite rapidly, it's always good to see what's available. Next slide, please. So just really thank you for giving up your lunch break to listen to more about insurance. So look, just want to give you an overview of Unity, if you haven't heard of us before. So we're specialist insurance advisors for the third sector, and all of our profits go back to helping children with skills for life. And we actually have a new strategy called Giving Children a Place to Belong. So if you found the content useful today and you would like just some advice and no pressure review, a 30-minute conversation, we're very happy to do that for you. Equally, if you just want to pick up the phone and have a conversation about what you're covered for, what you're not covered for, and just to explore your market options, we can equally do that as well. But there were some really practical things that you can do in the organisation. Even if you decide not to have a conversation, you can implement that at the board and actually understand what the risks are in the future. Thank you very much, everyone.
I think we're passing on to Rob now, I believe.
Yeah, so we'll go to questions and see what questions we have in the chat. Stop sharing.
No questions in the chat so far, but if someone wants to ask a question, we're happy to.
We're all happy, yeah. I think James has got something.
Yeah, go for it, James.
Hi, thanks for that. I'm just curious. I guess like all policies, these are annual, but issues could come out of the woodwork from previous years. Is it standard that these policies cover previous periods, or do you have to sort of kind of maintain, I don't know, sort of future cover with existing insurers?
Good question, actually. So the insurer that you're currently with it's done on something called a claims made basis, which means your insurer covers you for this current year and they'll cover you for the past, as long as there's no current issues or prior pending claims or investigations, covers up to that point. So actually your current insurer is the one that kicks in if anything in the past comes up. But that's a really good point, because you just generally in the trustee indemnity market, that's how it's done. So it covers you prior and pending. If they're asking for something like a retroactive date, just be very clear that you have that conversation with them, because it basically will mean that you would want to, it goes back to a certain date of cover, and that insurer will pick up that historic liability. So generally it's done in quite an easy way, as long as there's no issues in the past, which you would need to declare. But yeah, if it's done in a slightly different way, where it's talking about, I need a date to go back to, just be very clear about what that date is. Normally it will be cover that's been unbroken for a certain amount of time, and that's that date it will go back to essentially. But generally, it shouldn't ask that. But if it does, you're probably not with the right insurer in the nicest way.
I was just going to add to that as well. With Trustee's Indemnity, it's very important that you keep the cover continuous. So uninterrupted. As soon as you have a break in cover, so say for example there is you forget to renew or you don't purchase it, then there might be some conditions in that policy that mean that you might not be covered for the past. And that does depend on the insurer and the policy that you have it with, because some insurers are far more flexible and open-ended. So it's very important to have that in place. And equally, it doesn't mean you have to stay with that insurer. You can change insurers in the future, providing that there's no previous claims, or if there are claims or losses or incidents, then they're reported. And again, the whole purpose of Trustees Indemnity is not just to cover you if you are liable for a wrongful act or you've made a mistake in the organisation, but it covers you for allegations as well. So if someone points their finger at any particular trustee and says, you've done this, you've done that, and you need to defend that claim in the early stages, the insurers can support in that situation. Yeah.
Well, Peter's got his hand up.
Yeah,
go for it.
Thank you. I'm chair of trustees of a homeless charity on the south coast. We're an old-fashioned, I suppose, unincorporated charity. We've got an ancient trust deed. We're not a CIO, but we are also a limited company. So the myth then. So does being a limited company really give us no protection?
Your governance structure is an interesting one, because normally you can't have both a trust and a charitable company as one entity. It can be separate, so probably worth just looking at that. But apart from that, so no, a charitable company does give you lots of protection. It gives you protection against third parties. So because the law sees the company as a legal person, it's the company that enters into contracts with third parties, and so it's the company that buys the electricity, the gas, that enters into contracts to purchase goods. And therefore, if you don't pay, it's the company that is normally sued, not the trustees. The initial duties and responsibilities I was talking about are a breach of fiduciary duties is about your duty to the charity and to its beneficiaries, not to third parties. And it's that duty that's exactly the same whether you're a corporate charity or not. It's about and that some of those liabilities is what some of the trustee indemnity insurance will cover. But so that liability to your charity to fulfill your duties and not cause it a loss is the same for whether you're a company or not. It's duties to third parties that corporate status definitely 100% gives you lots of protection, and Catherine and I would highly recommend in most cases.
Yeah,
thank you.
I've got a couple of bits to add on that as well from an insurance perspective. So we do speak to charities often there might be an unincorporated trust and they want to become a CIO. And often what they don't realise is for the trust, if they had trustees indemnity in place for that organisation, or it was a small registered charity or unregistered charity, then as James highlighted earlier about, how does that cover need to be continuous? Well, it still needs to remain continuous, even if that organisation ceases to operate, because it only covers you whilst there is a live insurer in place at the time. So you need to continue purchasing trustees indemnity even if you change the structure of the entity itself, because insurers view that as a separate entity. So you need to have a separate trustees indemnity policy for the new organisation, the new CIO, and then purchase what we call run-off cover for the old organisation. So should any claims arise to the older organisation, that the cover still responds effectively. So that's worth considering. You can purchase run-off and you can buy it in bulk, for example, up to 6 years, which is normally the limitation period in the event of claims for for trustees. So, yeah.
You.
Great. Any other questions? Okay.